Well, folks, this document was filed on the 26th. Sorry for the delay. I've been real busy. Uh, Declaration of Isabella Salamana Nascimento under penalty of perjury. I am one of the attorneys for defendant Netflix Incorporated and above caption action. I have personal knowledge of the matter set forth herein. I make the declaration in support of Netflix motion to restrict made pursuant to General Local Rule 79D. And its request that this motion be denied. Attached hereto is Exhibit 1, a true and correct copy of the March 11th, 2022 email correspondence from Deborah Bursick, a member of plaintiff's legal team, preceding the documents responsive to the defendant's discovery request, March 11 production. None of the documents March 11 production were stamped with either a confidential or attorney eyes only designation. Exhibit 2 is a true and correct copy of March 25th email correspondence. The Netflix plaintiff's counsel requested to meet and confer. Exhibit 3 is a true and correct copy of April 4th email correspondence from counsel for Netflix and plaintiff's counsel providing an agenda in advance of the parties meet and confer scheduled April 6th. The parties meet and confer on April 6th and 7th regarding the relevant part. The plaintiff's over designation of emails in March 11th production of AOA. As a result of the parties meet and confer therein, the plaintiff agreed to revisit the blanket AEO designation in the March 11th production. Attached here to Exhibit 4 and a true correct copy of April 8th email correspondence from counsel for Netflix to plaintiff's counsel memorializing the outcome of the parties in April 6th and 7th meet and confers. Attached here to Exhibit 5 is a true and correct copy of April 12th email correspondence related to attached to plaintiff's counsel and counsel for Netflix, confirming counsel for Netflix April 8th summary of the meet and confers. Attached here to is Exhibit 6, a true and correct copy of April 14th email correspondence from Deborah Bursick, producing a supplemental set of documents responsive to the defendant's discovery request, April 14th production. None of the documents in April 14th production were ever stamped with either confidential or attorney's eyes only designation. Attached here to Exhibit 7, a true and correct copy of the April 19th email correspondence from the counsel of Netflix plaintiff counsel regarding the designation of all emails served on March 11th. Attached here to Exhibit 8, a true and correct copy of the April 22nd email correspondence from plaintiff's counsel responding to counsel Netflix April 19th correspondence. Exhibit 9 is a true and correct copy of the April 25th email correspondence from the counsel for Netflix to plaintiff's counsel regarding 5 emails produced by plaintiff as part of the April 14th production, which Netflix plans to file as exhibits in support of reply brief. Pursuant to the parties' stipulation governing production of the use of electronic stored information, ESI protocol, the parties agreed that confidential and attorney's eye only designations, if needed or required, and are to be placed on the bottom of the document, similarly to the court's protective order requires designation of information under the order, which must be made by placing or affixing in a document or material the words confidential or attorney eyes only, and further requires that such designations be made prior to contemporaneously with production. I declare under penalty of perjury that the foregoing is true and correct. Dated April 26, 2022. Exhibit 1. Email from Deborah Bursick to WalkerBallardSpear.com, whatever. All below for the downloading of the Colborn emails producing. They are marked Colborn at the time. All email messages are designated as attorney eyes only in production. Exhibit 2, another email to April Baker and George Burnett and Deborah Bursick. Dear George and April, thanks for the email below. All save discussion on the substance for our meet and confer, which we must insist we schedule for earlier next week. April, I know you will be on a well-deserved vacation, and I see no need to interrupt that given Mr. Colborn is represented by a team of 3 lawyers from 3 different law firms. George's office was involved in the designation of the Manitowoc documents In paragraph 6, it attached you identified George as lead counsel for the plaintiff and indicated that he was the ultimate decider of the plaintiff's side of the case when it comes to discovery disputes. George, please let us know how availability Monday and Tuesday for a call. In addition, in discussing the Manitowoc documents, we are very concerned by the over-designation of emails and text messages, the assertion of various privileges that obviously do not apply, including attorney-client privilege, spousal privilege, journalist privilege, and possibility priest-practitioner privilege, and the plaintiff's failure to comply with the ESI protocol, for example, but not using Bates numbers. While we leave to produce defendants to address plaintiff's failure to produce documents responsive to the producer-defendant's discovery request, we would like to discuss the problems with the plaintiff has produced in our meet and confer next week. George has offered to produce the documents as issue, and again, given his role as lead counsel and his many years of experience as a litigator, we assumed he is more than capable of handling the meet and confer in your absence, April. Of course, if the discovery deadlines didn't create some urgency, we would be happy to wait, but depositions must be concluded by May 20th. Even if discovery motions could be miraculously filed by Monday, they would not fully brief until May 2nd, and then the judge will need to decide them, and after decision, additional documents will likely need to be produced, some time of the essence. Meanwhile, we are beginning to prepare witnesses and may need to show and discuss them over designated documents Mr. Colborn has produced. So if we can reach some agreement on the designations, privileges, and production format during a meeting confer, that will be most helpful. Finally, I want to be very clear that, as I have said before, we are not treating the so-called privileged documents as privileged. They are not privileged, and an unliteral attempt to label them as such does not make them privileged. If you think they are privileged, then you should have taken immediate steps to claw them back. As we told you more than 3 weeks ago on March 4th, you took no such steps. You did not even respond to our letter until today. Please do not accept our silence on the substance of an email indicating agreement with anything you say. We look forward to chatting at George's earliest convenience. Lita Walker. This message responds to the letter on March 4th. With respect to the assertions regarding attorney-client privileges, as a local counsel well known, Wisconsin law is that the government employees occasionally personal use of government emails does not make the messages there in public records, Shield and Wisconsin Rapids School District. Rather, personal content of the emails are subject to release to record requested merely because they are sent to receive using the government employees' email system and then stored and maintained in those systems. Further, the fact that the county produced them would not waive Mr. Colborn's attorney-client privileges claims, as those can be waived only by client under well-established law. For the same reasons, the fact that we are distracted initially with the technical issues relating to the production in which we are of our firm's making, followed by the significant rush to designate these thousands of documents in accordance with your deadlines, could not waive Mr. Colborn's privileges claims. Even an attorney cannot waive a client's privilege claims without the client's consent. We obviously expect that you consider our designations. Notice that we contend that these documents are privileged under federal rule, civil procedure. A party who is notified of the material produced in discovery is privileged should properly return, sequester, destroy the specific information and any copies it has, must not use or disclose information until the claim is resolved, and must take responsibility steps to retrieve the information the party disclosed before being notified. With respect to the attorney's eyes only designation, as specifically advised that these designations were made because we were advised that the third-party ESI service that we used, they could not remove a personal identifying information, such as phone numbers, email address. Also advised that we would prepare in-house versions of the same documents that admitted there, therefore could be merely designated as confidential rather than attorney's eye only. We intend to provide these versions in advance of any scheduled depositions. In an interim, it's more responsible for us to honor Mr. Colborn's attempt to protect himself and his friends, acquaintances, and family members from the obvious potential of further intrusion into his private life and the lives and those of friends and family members that would result in our clients personally obtained and eventually released into the public domain. The private email addresses physical addresses, telephone numbers of Mr. Colborn and those close to him, and the numerous threats were leveled at Mr. Colborn during the MAM demonstrate. Litigant concerns transcend even privacy and the rise of the level of safety concerns. Recent discovery requests provided further reason to be concerned that the clients are quest to promote their storyline, idolizing Stephen Avery and villainizing Mr. Colborn, and we do not want Mr. Colborn's personal address book made available as a playbook for making a murderer. 3. Are you kidding me? Finally, I have note to relocation. You have only produced a handful of documents that were not subject to confidential designations. Those few consisted almost entirely, if not entirely, of public trademark filings. When previous asked you to reconsider your confidentiality designations for email messages, except between Netflix representatives relating to MAM production, you offer no purported justification of the designations, indicating only that you were not willing to consider removing them, except on a case-by-case basis, so that we would obstinately have to debate with you the merits of each individual document among thousands in your production. In the light above, I agree that the meet and confer would be appropriate after I return from planned family vacation next week, in which I mentioned earlier in the context of depositions because we were looking at March, April deposition dates prior to the stipulation extended deposition deadline, April. Supplemental Declaration, April Roxy Baker. I, April Roxy Baker, declare under penalty of perjury as follows. I am one of the attorneys for the plaintiff in the above captioned action. Attached Exhibit 1 is a true correct copy of email messages that I sent to counsel of the defendants, including Lita Walker, counsel for Netflix, in July 28, 2021. To my knowledge, I never received a response specific to my request for production of non-confidential documents. Attached is Exhibit 2, a true and correct copy of the email message I sent to Lita Walker on June 24, 2021, and early July through mid-July of this year. I was also in communication with the defendants' counsel regarding a supplemental joint discovery report the defendants proposed. Attached to Exhibit 3 are true and correct copies of portions of the document that was contained in the first document production by Netflix Incorporated on September 17, 2021. Attached is Group Exhibit 4 is a true correct copy of the email exchange that I had with Lita Walker in response to October 2, 2020 in correspondence. During the December 16, 2021 meeting confer with defendants' counsel, I did not indicate or manifest acceptance of the terms or timing of production that Netflix early informed me would be following. Rather, I stated at the outset of the call that I thought they were unfortunately unlikely to make any progress unless defendants indicated that they would be providing documents within a week or so. After Ms. Walker described Netflix timetable for production, I indicated to the counsel on the call that I would have to talk to Attorney Burnett, lead counsel for plaintiff, to determine whether we would accept the proposal in the resolution of the discovery dispute. Attorney Walker demonstrated understanding to this, stating something to the effect of, "You talk to George." After Burnett did not find Netflix's proposed timetable agreeable, further discussions would have been futile after that point. Attorney Walker's statement to the offer to provide extension to the plaintiff to respond to discovery responses served by Netflix Incorporated on plaintiff is not true to the extent that she may be contending that she offered an unconditional extension to me that was there for the asking. During the September 16, 2021 call, I asked Ms. Walker if she would extend the deadline for responses given that Netflix had to produce the documents the plaintiff requested in June. Ms. Walker responded that she would consider, emphasizing the word, providing an extension of we provided specific reasons for extension. Otherwise, she firmly indicated that Netflix would expect timely written responses to the discovery. To my recollection and understanding, she disagreed with the suggestion that the timing of Netflix production, along with the justifiable reasons for extension of deadline, responded to Netflix. And an email, based on the court's comments today, it appears that something more substantive will have to be submitted before the judge will agree to enter a production order. I assume that you are likely preparing something for the court in that regard. In the meantime, in the interest of avoiding further delay, we would like to move forward with respect to responsive discovery materials that would not be designated as confidential under protective order when entered. Please confirm the materials that are not claimed to be confidential can be forwarded while we sort out protective order issues. Thanks very much. April Baker, June 24th email. Normally I would have sent them by email as well, but been intubated with matters that have waited while I was out of the office for essentially 3 weeks through my mother's hospitalization, transfer to hospice, and passing. In addition, have coworkers here asking me to help them with urgent matters with deadline. And I'm still dealing with the issues that need to be addressed for the mother's final affairs. I have very little staff help available to me, as well as pandemic or no, unfortunately. So I can assure you that it was simply a matter that I literally had to get those in the envelopes and mail on the way out the door, and had no opportunity to go down to the one scanner I could use on this lower level before I had to get another obligation that day, and then desist the urgent briefing deadline all day the following day, and have been preparing for oral argument out of town yesterday. Since then, certainly no offense was intended to sending them via mail. In calmer times, I will of course endeavor to send documents via email. I've already read this in previous videos. Just receipts and stuff. Alright. Lita, I cannot respond to the entirety of her response immediately, but suffice to say that I disagree with virtually all of it, including the way you characterized our conversation on December 16th. However, to clarify initial matter, your discovery requests were only validly served on us by mail because we did not consent the service by email, as you acknowledged in your recent message. Therefore, 3 days are added to the response period under Federal Rule of Civil Procedure. Accordingly, the responses are timely. April, thanks for your email. Please let me know when you can respond substantively to the letters and whether you will withdraw the motion for sanctions. I cannot respond to your entire correspondence immediately, but suffice to say I disagree with virtually all of it. That's just a response to that one. Exhibit 3. Good morning, Council. April, I hope you have a good vacation. We're ready to schedule a meet and confer for this week. I need to check with the colleagues here at Ballard for availability, but to get the ball rolling, I'm opening during the following windows of time. Tuesday, except for around 2:45, 4:15, Wednesday, 11:30, Thursday, between 11 and 3. Here are the items Netflix would like to discuss. Council producer defendants may have additional questions. All these items should be radar already through prior correspondence. We have just complied them for the convenience. Separately produced documents referred will be sent those separate email facilitate the discussion. Manitowoc County documents. We are using Manitowoc County documents produced by your team on February 9th, 2022, and we have discarded the subsequent set of documents produced by your team on February 28th, 2022. Do you agree that the parties will use Mr. Colborn's personal file as bait stamped by Netflix? Answer, if so, Netflix shall apply the confidential destination of these documents as you requested and produce the records to all parties according with the ESI protocol. Do you agree with producer deduped Manitowoc County documents as we requested by email? Of course, what is that even supposed to mean? Alright, with regard to your claim that some of these documents may be privileged, some of the Manitowoc County documents which you have claimed privilege were also produced in whole or in part by Netflix and indicated by the FOIA Bates labeled, you will withdraw your claim of privilege of those documents. For example, Mr. Colborn's communications with Patrick O. Dunphy, Mr. Colborn's communications with Matthew F. Fisher, and Mr. Colborn's communications with Gerald I. Dietz. Do you also agree with the withdrawal of the claim of attorney-client privilege with respect to the communications that Mr. Colborn forwarded in a whole part or third party, Brenda Schuler, for example, Mr. Colborn's communication with Patrick O. Dunphy, and Mr. Colborn's communication with Matthew V. Fisher? Interesting. Will you agree to revisit the confidential EOA destination of these documents, remove all AOA destinations, and will you also review all confidential designations unless the document could be properly withheld under open records law? Additional privilege designations. Do you agree with the withdrawal of the assertion of the third-party journalist privilege with respect to documents and the communications withheld and redacted on the basis, and to produce all such records in full of the defendants, for example, in the production of Mr. Colborn's text messages? You withheld in full text message exchange between Mr. Colborn and Brendan Schuler, Sean Reck, and Emily Metastic. Wisconsin reporter's privilege does not apply to non-journalists such as Mr. Colborn. Further, he has put these emails in issue the response to Chrome Integrity, stating that disclosed how MAM has caused me damage to producers of upcoming documentary. Do you agree to waive the assertion of the priest practitioner privilege where respect to Pastor Tom Pankow, whom you have identified as a damages witness for Mr. Colborn? Do you agree with the waive the assertion of the spousal privilege with respect to all documents and communications withheld or redacted in the spaces between Mr. Colborn and Barb Colborn, as Ms. Colborn has identified the dissolution of his marriage as an alleged damage, and also has identified Ms. Colborn as damages witness? February 28th and March 3rd, Colborn text message production. The text messages were not produced in accordance with the parties' ESI protocol, including because they lack Bates labeling. Please reproduce the productions with exact text entry Bates labeled. The text messages productions are also deficient, and they were not produced with the metadata or as members of families. In addition, there are also at least 32 text messages where the body field is blank, and there is an indication there was an attachment. We do not want you to reproduce the entire production, but you are willing, upon our identification of specific text messages, including those we intend to use in any briefing to the court and any hearing trial proceeding, to promptly produce those specific messages in accordance with the ESI protocol. March 11th, Colborn email production. On what basis are you asserting that all emails on March 11th production of Mr. Colborn's emails are designated attorney eyes only? Damages witnesses. When all the supplement to your January 28, 2021 and February 16, 2021 responses produced to the defendant's interrogatory number 10, which called on you to provide individuals' full name, present, or that is not known, last known addresses, telephone numbers, email address, occupation, and present to the last known employer, as well as the substance of each person's knowledge. In addition, requiring contact information and subsequent knowledge for those individuals identified on February 16th, defendants also require complete identifying information of substantive knowledge of the individual described in vague detail in your January 28th response. Do you anticipate producing documents in response to Netflix second RFPs on Wednesday, April 6th? If not, what is your plan for production and response of records? When will the parties receive deposition orders for depositions planned for the last week of April, including April 26th, Adam Del Dio, April 27th through the 28th, Laura Riccardi and Maura Demos, and April 29th, Lisa Nishimura? Exhibit 4. Another email. I write to memorialize the outcome of our meet and confer, which took place on April 6th and 7th. Please find summaries for the discussion below on relevant topics for convenience. Also have attached April's 2 emails responding to the email below and Kevin's deficiency letter. I am not attempting to summarize the discussion of the topics Kevin raised during our meet and confer. Kevin, I assume you may send your own email on that by replying to all the correspondence so everything is in one place. Lita. Good morning, Council April. I hope you had a good vacation. We're writing schedule meet to confer for the week. I need to check with the colleagues here at Ballard availability. I already read this. This is just a response to that one email. Alright, Manitowoc County documents. February 9th, we have discarded subsequent set documents produced by the team on February 28th, 2022. Do you agree with the parties will use Mr. Colborn's personal file as bait stamp by Netflix? If so, Netflix shall apply the confidential designation to these documents as you requested and produce the records to all parties according to the ESI protocol. All parties are in agreement with the 1 and 2 above and will produce accordingly. Do you agree to produce and deduped Manitowoc County documents as we requested by email correspondence for February 17th, 2022? The parties agree that the first set of Manitowoc County documents which the team produced to us were deduped, and we asked you to confirm whether the second set where your team produced was the complete set or whether it was similarly deduped. Never indicated that the second production of these documents is complete set with no duplications removed. We offered to try to compare the two productions to determine whether they deduped from the first set. We told you that if we were unable to complete the comparison, we would likely ask you to provide a declaration regarding how documents were deduped, and from the first set of the confirming omitted documents can be identified as produced to us. With regard to claim some of the documents may be privileged. Some of the Manitowoc County documents for which you claim privilege were also produced in whole or in part by Netflix, as indicated by the FOA Bates label. Will you withdraw your claimed privilege as documents, for example, Mr. Colborn's communication with Patrick Dunphy, Matthew Fisher, and Geraldine Dietz? We provided several reasons why these documents are not privileged. First, we explained that the documents were never privileged because plaintiff communicated using the Manitowoc County email addresses in which he held no reasonable expectation of privacy. Manitowoc County's computer use policy clear that such communications can be accessed any time. Plaintiff signed and acknowledged of this policy, indicating the understanding and acceptance of this policy. Second, we explained that even if they were privileged at the time of creation, these documents have now been in the public domain for so long that any privilege is long gone. We explained that the documents with the prefix FOIA were produced by Manitowoc County pursuant to Wisconsin's public records law to members of the public, not to anyone from Netflix or Ballard, and many of them were posted online long ago. The cat cannot be put back in the bag. Neither Colborn nor the court has any authority to claw back these documents from the third parties, whether individuals or social media platforms such as Reddit. Likewise, they cannot enjoin their further distribution. These documents are now individually public, and their disclosure results in subject matter waiver any privilege that might otherwise protect them or otherwise related communications. You disagree with the indicated that we would be moving to compel on this issue, and they indicated that we should do so as parties would not reach agreement at this point. Further indicated that the motion to compel would need to seek a ruling on both the privilege as the documents and the scope, a question of the plaintiff, and the deposition above, the records of subject contained therein. Do you also agree to withdraw any claim of attorney-client privileges with respect to communications that Mr. Colborn forwarded in whole or in part to third-party Brenda Schuler, Patrick O. Dunphy, or Matthew F. Fisher? With respect to communications between plaintiff and counsel, our prospective counsel, we explained that even assuming for the sake of argument that these were once privileged, that privilege was waived by plaintiff when he forwarded the communications to non-attorney third parties, such as Brenda Schuler. You generally agreed that the communications revealed to others who do not share an agency relationship are not privileged. You indicated that you would access whether there is an agency relationship with Schuler and provided us plaintiff's position next week. You said you were talking to Mr. Colborn Monday and would endeavor to give us a definite answer no later than Tuesday, April 12th. We followed up their substantial overlap between the documents produced by Manitowoc County in response to public records requests and the communications which plaintiff forwarded to Brenda Schuler were additionally indicated that finding a waiver of these communications would result in a subject matter waiver. You indicated that you would review the scope of the subject matter waiver to provide us plaintiff's position on that as well. Please note that to take the position of Ms. Schuler's or Mr. Colborn's agent, we will accept to see a documentation of the relationship that exists in addition to any release or other contact he has related to Ms. Schuler's film project. Will you agree to revisit confidential AOA designation documents and remove all AOA designations? Will you also review confidential designations unless document could be properly withheld under the open records law? You indicated that you would review the confidential AOA designation for the documents produced in response to Netflix subpoena to Manitowoc County and provide a U.S. plaintiff's position and designations next week. We indicated the two would be part of the motion to compel in which we would seek recovery of fees if agreement cannot be reached. Additional privilege designations. Do you agree with the withdrawal of the assertion of third-party journalist privilege with respect to any documents or communications withheld, redacted on the basis, and to produce all such records to to defendants? For example, in your production of Mr. Colborn's text messages, which held the full text message exchange between Mr. Colborn and Brenda Schuler, Sean Reck, and Emily Matasic, Wisconsin reported privilege does not apply to non-journalists such as Mr. Colborn. Further, he has put these emails and issued a response to Chrome Integrity number 10, stating that disclose how MAM has caused him damage to producers of any upcoming documentary. With respect to plaintiff's assertion of third-party journalist privilege, we explained that the plaintiff has no standing to assert the purported privilege. We further explained that although the journalist can assert the privilege with a subpoena, as dictated, the journalist seeks documents in journalist's possession. The discovery requests at issue here were directed to Mr. Colborn. No journalist can preclude to source such as Mr. Colborn from complying with discovery obligations. Here, those obligations, including producing documents in the possession, custody, control that are responsive to the defendant's discovery requests, including correspondence with the journalists and filmmakers. One primary purpose of the reporter's privilege is to prevent lawyers and litigants from using journalists as free investigators rather than complying with the responsibility to conduct discovery from the parties to the reaction. Indeed, the Wisconsin statute of the reporter's privilege includes an exhaustion component which requires the requester of the request to attempt to procure the records from all sources, which here would be plaintiff. You clarified that the plaintiff is not himself asserting the reporter's privilege, and that you agree that he does not satisfy the newsperson definition in the statute. You said that the journalists with whom plaintiff was communicating are now claiming that the responsive information is privileged, and that you should not disclose it, and that you are offering the individuals the opportunity to assert their own privilege off of this information. We informed you to the issue of this close call. We will be moving to compel production of these responsive documents, seeking fees unless plaintiff agrees to produce all responsive records that have been withheld and to produce redacted records, unredacted from, and you indicated you would let us know from final position promptly next week. Curious to what Emily Matasic has to contribute to this, because not a lot of you guys might recognize some of these names, but I surely do, like Mr. Pankow. With respect to all April 10th depositions of Pastor Thomas Pankow, Barbara Colborn, April indicated that she is available on the date and will appear on behalf of plaintiff. Kevin indicated he will participate remotely on behalf of producer defendants. April, just let us know whether we should expect you in person or remotely, and if remote, we will send you both and Kevin a link so as soon as we have it set up. Regarding the clergy, parishioner, and spousal privileges, we stated that we are deposing the pastor and Mr. Colborn's ex-wife, primarily because he identified them as damages witnesses, and we do not want to waste time as depositions by unaccepted assertion of privilege. George indicated that whether the privilege applies to the dependent on the questions being asked, and the plaintiff agrees that the claims for damages based on conversations with these witnesses over which he claims a privilege cannot then be introduced as later time against the defendants. We further explained that the driving forces behind the need to depose these individuals are the plaintiff's intentional infliction of emotional distress claim and his allegation that the documentary was the cause of his divorce. In response to George's question about it, his plaintiff withdrew the allegation of the divorce being caused by a documentary, whether that would eliminate the need to depose Miss Colborn. We indicated that we would need to withdraw at least the IIED claim, that the divorce allegation and the likely agreement that should not be used witness in trial, but we indicated that even then Miss Colborn is uniquely situated to provide relevant testimony on plaintiff's garden variety claim for damages in a defamation case. Withdrawal of the IIED claim and the divorce allegations would significantly reduce the scope of these witnesses' depositions, though. You will ultimately inform that you were conferred with plaintiff about whether he will waive any claim of clergy, patronage, or spousal privileges, and inform us as soon as possible next week. If plaintiff agrees that the privileges, will also accept him to produce any documents he withheld on the basis of these privileges. If he does not waive the privileges, we likely will bring a motion on the issue and will seek fees. February 28th to March 3rd, Colborn text message production. The text messages were not produced in accordance with the parties' ESI protocol and includes because they lacked Bates labeling. Please reproduce productions with each text entry Bates labeled. The text message productions are also deficient in that they were not produced with metadata. What a surprise. Or as members of the families indication that 32 text messages where the body filed a blank and there's an indication there was an attachment. We do not want you to reproduce an entire production, but you are willing to, upon identification of specific text messages, including those we intend to use in a briefing to the court and in a hearing in a trial proceeding. I wonder if they could subpoena REC, and this is going to get interesting. Properly produce the specific messages in accordance with ESI protocol. These difficulties were identified with production, and they were unable to code, filter, or configure the spreadsheets in any meaningful way without destroying their originality, integrity, and losing the ability to go back to square one, and that we have been unable to ascertain the attachments correspondence with relevant blank fields in the spreadsheets. We propose simply adding a column in the spreadsheets and providing a uniform prefix such as Colborn text 001, which would then increase sequentially the applied across the spreadsheets of text messages. The parties could then refer to the individual text according to each text unique identifier. Deborah expressed concern that adding such a column would decouple the computer links to the respective attachments. So Deborah will check with the e-discovery provider and quickly let us know about the possibility of providing a uniform label to the text messages according to the spreadsheet. We indicated that we would continue to try to figure out which attachments correspond to the respective blank fields in accordance with the provided instructions. So it sounds like Netflix received information from Colborn, but it was blank. On what basis are you asserting that all emails in the March 11th production of Mr. Colborn emails are designated attorney eyes only? We ask that you revisit your blanket designation of all plaintiffs' emails and attorney eyes only. You are agreed to do so, and the parties agreed that you would provide us an Excel spreadsheet with the confidentiality designation for these documents, which our e-discovery team will apply to the documents. Damages witnesses. When will you supplement your January 28th, 21 and February 16th, 21 response to the producer defendant's integrity number 10, which called on you to provide the individual's full name, present, or that is unknown, last known address, telephone number, email address, occupation, and present or last known employer, as well as subsequent each person's knowledge. In addition, requiring the contact information and subsequent knowledge of the individuals identified on February 16th. Defendants also require complete identifying information and subsequent knowledge for all individuals described in vague detail in January 20th response. With respect to outstanding information regarding the witnesses, plaintiff identified response to producer defendant's integrity number 10. George indicated that he will ask plaintiff to provide telephone numbers or other forms of contact such as email addresses in advance of counsel's meeting with plaintiff that is scheduled Monday. George indicated that we can accept a short description of the substance of each person's knowledge relevant to plaintiff's damages claims after counsel's meet with plaintiff on Monday. Additional questions. Do you anticipate producing documents in response to Netflix second RFPs on Wednesday, April 6th? If not, what is your planned production in response to records? We received your latest production, so thank you. Deborah indicated that at the time plaintiff does not anticipate any further productions in response to Netflix RFPs. When will all parties receive deposition notice of depositions planned for last week, April, including April 26th, Adam Del Deo, April 27th and 28th, Laura Riccardi, more demos, and on April 28th, Lisa Nizamura. With respect to the notice of the deposition of those Netflix deponents listed above, Deborah emailed us shortly after the meeting, and we informed you at 8 a.m. Pacific time did not work for Netflix witnesses as suggested at 10 a.m. Pacific time start. We also discussed a few topics in the April 4th email. With respect to Mr. Griesbach books, we agreed to provide you with copies of the copyright pages from the books, which we may use to ensure all the parties are working from the same editions. You indicated that this would suffice and that we did not need to produce the books to you at the time. You would produce copies to the extended books of these already available through Mr. Griesbach's. Further, on the motion of Lehman related to the Mr. Griesbach, we also whether plaintiffs would stipulate to a brief scheduling that the schedule closer to the time of the trial in the case, which has yet to be scheduled. We further inform that we will move to such briefing schedule as the court has no reason to yet resolve this issue and parties have other pressing discovery matters to resolve. You indicated that you will confer as a team and promptly inform us whether you will agree to stipulated briefing schedule or whether you would oppose our motion. April indicated that Mr. Colborn brought the motion in named hopes of somehow heading off disclosure of a large number of documents by Mr. Griesbach, and that would be time-consuming to review during an already busy period of discovery. We said we did not know how many responsive documents Mr. Griesbach had, and that our meet and confer with counsel was extremely unproductive, and the counsel did not agree to voluntarily disclose any documents upon further reflection. I would now note that whether the outcome of the motion, such motions go unadmissibly, non-discoverably. So regardless whether the motion decided, our position is that we entitled to Mr. Griesbach's documents for the reasons set forth in our motion to compel, thus briefing the motion over the next few weeks. Rather than closer to trial, we will in no way alleviate April's concerns about the new need to review additional documents and will in fact just add to everyone's already full plates. Further, it will be difficult for us to respond completely to the motion until we are able to see the documents that we requested of Mr. Griesbach. Finally, I wanted to make clear Netflix's position regarding the new items in April's attached email. April wrote, "We also remind you that we consented to the extension of many of your deadlines in the case for the purpose of allowing time for discussion and resolution of the alleged issues in that extent possible. Netflix has not sought any extension from the court in this case. Plaintiff and the producer defendants have sought extensions, which Netflix did not oppose. The one time Netflix indicated it needed a bit more time to get documents to you last October, you moved for sanctions, a motion you later withdrew." April wrote, "Finally, with respect to the Netflix designation and email messages involving MAM's production as confidential, we reiterate our concern that you have failed to supply any rationale for these designations in response to our prior inquiries. The problem that it creates that according to local rule, a protected order is not sufficient basis for filing documents under the seal. A separate request must be made identifying the basis for designations. When we file our response to your eventual summary judgment motion, we will not have any basis for representing to the court that they should be filed under seal, because you have not articulated one. In the absence of any plausible rationale sealing these documents, we will need to seek direction from the court. We will, in advance of summary judgment, briefing regarding the proper treatment of these documents so that we are not caught in bind during summary judgment briefing. I don't believe we have failed to respond to any inquiry about this, and if you can't point to a specific inquiry, we will try to find a response to the inquiry for you. At present, unless someone moves to the court for intervention or designations, it seems we will all be in the same boat come time for summary judgment, since you, too, have designated nearly everything confidential. In fact, unlike Netflix, and is discussed above and during phone calls, you have designated a significant percentage of your production as attorney eyes only. We are open to any suggestion you want to make how to deal with this. We are 100% agree that our over-designation unnecessarily complicates this case. That said, we do not believe we have over-designated." April wrote, Please also note that we have not completed an exhaustive list of deficiencies with the defendant's productions and then reserve the right to request additional meet and confer conferences as many be necessary and appropriate as we continue to review our analysis of Netflix Chrome productions. We are not sure which of the defendants you are talking about here. Are you concerned that you continue to conflate Netflix with producer defendants in asserting you have granted us many extensions? That said, we are always willing to meet or confer, though we would be surprised to learn at this late date that you believe our discovery responses in any way deficient. Although you have certainly had questions about the production related to raw footage of Google Docs, we have answered those questions. You have never identified any actual deficiencies, despite our serving written responses 9 months ago and finishing our document production 5 months ago on October 28th. Accept all the small set of documents we expect to produce in the very near future that are responsive to your recently served 7th set. Exhibit 5. Another email. I have attached you documents that contain Kevin and Lita's messages from Friday with their response to boldface type. In order to avoid confusion, I removed boldface from some of the Lita's headings that are still underlined. It seemed that you would be unwilling to try to send these responses with an email message at the point, and I was concerned that it might lose front coloring and highlighting to distinguish whose comments were made by which speaker at this point. If I missed the issue, please let me know. April. Here are the items Netflix would like to discuss. Counsel for producer defendants may have additional questions. All these items should be on your radar, although already through prior correspondence, we have complied with here to convenience several produced documents referred, and we will send those separate email to facilitate the discussion. Manitowoc County documents. We are using Manitowoc County documents produced by our team on February 9th, 2022, and we have discarded the subsequent set of documents provided by our team on February 28th. Do you agree that the parties will use Mr. Colborn's personal file as bait stamped by Netflix as MSC Manitowoc Sheriff 00011127? If so, Netflix shall apply the confidential designation of these documents as you requested and produce the records to all parties in accordance with the ESI protocol. All parties in agreement with number 1 and 2 above will proceed accordingly. You agree with the dedupe? I already read this. Seems like it's a duplication, but I'll read it anyways. Agree to produce the dedupe Manitowoc County documents that was requested by email correspondence for February 17th. The parties agree that the first set of Manitowoc County documents which your team produced to us were deduped, and we asked you to confirm whether the second set where your team produced was the complete set or whether it was simply deduped. That would indicate that the second production of the documents to complete set with no duplications removed. We offered to try to compare the two productions and determine whether they're deduped from the first set. We told you that if they're unable to complete the comparison, we likely will ask you to provide a declaration regarding the new documents were deduped from the first set and confirming omitted documents identified and produced to us. With regard to our claim that these documents may be privileged, some of the Manitowoc County documents which claim privilege are also produced in whole or in part by Netflix and indicated by FOIA baits labeled. Will you withdraw your claim to privilege of these documents? For example, Colborn's communications, Patrick O. Dunphy, Matthew F. Vischer, and Geraldine Dietz. We provided several reasons why these documents are not privileged. First, we explained that the documents were never privileged because the plaintiff communicated using Manitowoc County's email address in which he had held no responsible or explanation of privacy. Manitowoc County's computer usage policy clears that the communication can be accessed anytime. Plaintiff signed his acknowledgement of this policy, indicating that understanding and acceptance of this policy. Second, we explained that even if there was privilege at the time of its creation, these documents have been known in the public domain for long, that any privilege is long gone. We explained that the documents prefix FOIA produced in Manitowoc County pursuant to Wisconsin public records law and members of the public to anyone from Netflix and Ballard. Any of them were posted online long ago. The cat cannot be put back in the bag. Neither Colborn nor the court has any authority to claw back these documents from the third parties, whether individuals, social media platforms such as Reddit. Likewise, they cannot enjoin their further distribution. These documents are now irreparably public, and the disclosure results in a subject matter waiver and privilege that might otherwise protect other related communications. You disagreed. We indicated that we would be moving to compel this issue and indicated that we should do so. The parties would not reach agreement to this point. Your further indication that any motion to compel would need to seek a ruling in both the privilege of the documents and the scope and the question the plaintiff has a deposition about 3 records of the subjects contained therein. Do you also agree with the withdrawal any claim attorney-client privileges with respect to the communication Mr. Colborn forwarded in whole and or in part to the third party, Brenda Schuler, for example, Mr. Colborn's communication with Patrick L. Dunphy and Matthew S. Fisher? With respect to the communications between plaintiff and counsel or prospective counsel, we explain that even assuming the sake of argument these were once privileged, that privilege was waived by plaintiff when he forwarded his communications to non-attorney third parties, such as Brenda Schuler. You generally agree that the communications revealed to others who don't share an agency relationship are not privileged. You indicated that you would access whether their agency relationship with Schuler provided the plaintiff position next week. You said you were talking to Mr. Colborn Monday and would endeavor to give us a definition answer later on that Tuesday, April 12th. We followed up there to some sort of overlap between the documents produced by Manitowoc County in response to public records request. The communications which plaintiff forwarded to Brenda Schuler, we additionally indicated that finding the waiver of those communications would result in subject matter waiver. You indicated that you would review the scope of the subject matter waiver and provide plaintiff's position on it as well. Please note that if you take the position of Ms. Schuler or as Mr. Colborn's agent, we will accept to see any documentation of that relationship that exists in addition to the release of other contract he has related to Ms. Schuler's from film project. We can agree that the documents forwarded by Mr. Colborn to other individuals who are not attorneys and to whom there is no privilege or privileged. We will produce such documents without AOA designations. We do not have authority from our client at this time to enter any stipulation there has been subject matter waiver. Will you agree to revisit the confidentially AOA designations on these documents and remove all AOA designations? Will you also review all confidentiality designations unless the document could be properly withheld under the open records law? You indicated that you would review the confidential AOA designations and documents produced in response to Netflix subpoena to Manitowoc counties and would provide a plaintiff's position in the designation next week. We indicated that 2 would be part of the motion to compel, in which we would seek recovery of fees if agreement cannot be reached. We can provide revised designations by the end of the week. We agreed to participate in the motion and extend the defendant's deadlines at Chrome's request, but we also benefiting Netflix specifically to allow time to attempt to comprise with respect to the issues that you raised, a reasonable pace given the amount of material involved, and the fact that the team members are primarily handling some of these matters are involved in other active litigation cases as well. Therefore, we do not believe that the timelines are responsible. Addition, privilege designations. Do you agree with the withdrawal assertion of third-party journalist privilege with respect to any documents or communications withheld or redacted of the basis or produce all such records as a full defendants? For example, if your production of Mr. Colborn's text messages you withheld in full text message exchange between Mr. Colborn, Ms. Brenda Schuler, Sean Reck, or Emily Matastic, Wisconsin reporter's privilege does not apply to non-journalists such as Mr. Colborn. Further, he was put these emails in issued response to Chrome's integrity number 10, saying to disclose how MAM has caused me damage to producers of upcoming documentary. With respect to the plaintiff's assertion of the third-party journalist privilege, we explained that the plaintiff has no standing to assert the reporter's privilege. We further explained that although a journalist can assert the privilege when a subpoena is directed at a journalist and seeks documents in a journalist's possession, discovery requests the issue where the director of Mr. Colborn, no journalist can preclude or source such as Mr. Colborn from complying with discovery obligations. Here, those obligations include producing documents in possession, custody, or control that are responsive to the defendant's discovery requests, including his correspondence with journalists and filmmakers. One primary purpose of this reported privilege is to prevent lawyers and litigants from using journalists as free investigators rather than complying with their responsibility to conduct discovery from the parties to the action. Indeed, the Wisconsin statute of reporter's privilege includes the exhaustion component, which requires requester of the records to attempt to procure the records from all sources, which here would be plaintiff. You clarified that the plaintiff is not himself asserting the reporter's privilege, and that you agree he does not satisfy the newsperson definition in the statute. You said that the journalists with whom plaintiff was communicating with are now claiming that the responsive information is privileged and that you should not disclose it. And you are offering these individuals the opportunity to assert their own private privilege over this information. We informed you that the issue is not close to call. We will be moving to compel production of these responsive documents and seeking fees unless plaintiff agrees to produce all responsive records that has been withheld. In order to produce redacted records in unredacted form, you indicated you would let us know your final position promptly next week. Counsel for WBAY and the Wall Street Journal have indicated, subsequent to the conference with you last week, that they will not seek protection for these communications in these proceedings. Accordingly, those communications will be produced. I note that Craig Linder, counsel for the Wall Street Journal, indicated that he did not necessarily agree with the assertion that the subpoena to be resourced such as Mr. Colborn would not trigger potential journalist privilege protection. My understanding is that the Wall Street Journal could have contended a broader privilege applied, such as under New York's journalist privilege. This issue demonstrates why we would not simply assume, based on the wording of Wisconsin statute, that your analysis was correct. However, Mr. Linder indicated that he had concluded that the content an issue was not sufficiently sensitive to warrant the effort to become involved in this case. With respect to the communications with Brenda Schuler and Sean Reck, they have asked that we designate any such communications as confidential, pursuant to the protective order, because they are in production and communications related to as yet unreleased work. If you object to such designations, please advise. Please keep in mind that you have to date refused to relinquish your own designations at Netflix email communications as confidential. It may be that we will be able to reach some agreement to seek permission from court to file documents designation as confidential under seal without the need to go through local producers as to each document for purposes of later motion practice. Do you agree to waive any assertion, priest, and parishioner privilege with respect to Pastor Tom Pankow, whom you have identified as damages witness to Mr. Colborn? Mr. Colborn does not assert priest, parishioner privilege with respect to Pastor Tom Pankow. Do you agree to waive any assertion of the spousal privilege with respect to the documents and communications withheld or redacted on the basis between Mr. Colborn, Barb Colborn, as Mr. Colborn identified that the dissolution of his marriage as an alleged damage, as also identified Mr. Colborn as damages witness? With respect to the April 18th deposition of Pastor Thomas Pankow and Barbara Colborn, April indicated that she is available on this day and will appear on behalf of plaintiff. Kevin indicated that he would participate remotely on behalf of producer defendants. April just let us know whether you should expect us to be remotely. If remote, it's been on the line as soon as it's been set up. Regarding the clergy, parishioner, and spousal privileges, we stated that we were deposing the pastor and Mr. Colborn's ex-wife, primarily because he identified them as damages witnesses, and we don't want to waste time at the depositions by any unexpected assertion of privilege. George indicated that whether the privilege applies to the defendant on the questions being asked, but the plaintiff agrees that the claims of damages based on conversations with either of these witnesses, over which he claims a privilege cannot be introduced at a later time against the defendants. We further explain that the driving forces between the need to depose these individuals are plaintiff's intentional infliction of an emotional distress claim and his allegation that the documentary was the cause of his divorce. In response to the George question about it, if plaintiffs withdrew the allegation about the divorce being caused by the documentary, whether that would eliminate the need to depose Mr. Colborn or Miss Colborn, we indicated that it would need withdrawal at least the IIED claim, the divorce allegation, and likely an agreement that she could not be used as a witness at trial, but indicated that even then, Miss Colborn is uniquely situated to provide relevant testimony on plaintiff's garden variety claim for damages in a defamation case. Withdrawal of the IIED claim and the divorce allegations would significantly reduce the scope of these witnesses' depositions thorough. You ultimately informed that you would confer with the plaintiff about whether he had waived any claim of the clearly parishioner and spousal privileges and inform us as soon as possible next week. If plaintiff agrees to waive the privileges, we also expect him to produce any documents he withheld on the basis of these privileges. If he does not waive the privileges, we likely will bring a motion on the issue and will seek fees. Mr. Colborn will waive spousal privilege and also withdraws for purpose of these proceedings and to streamline the litigation only. The assertion that MAM caused his divorce. February 28th and March 3rd. Conclusion. Text message production. The text messages were not produced in accordance with the parties' ESI protocol, including because they lack Bates labeling. Please reproduce productions which each text entirely Bates labeled. The text messages productions are also deficient and they were not produced. The metadata, they're all blank. I've read this like 3 times now. The difficulties were identified in production. They're unable to code, filter, reconfigure spreadsheets in the meaningful without destroying the original. Yeah, I read this already. This is like the same thing over and over. All right. We are advised that the ESI provided defendant should be able to insert the column of the Excel spreadsheet and keep the spreadsheet with other files so that it does not lose data and attachments. However, the various spreadsheets cannot be combined easily. There were 3 spreadsheets produced as the data came from 3 different phones. Our e-discovery providers indicated would be taken. Further research to see the data between phones combined. Defendants wish to pursue that they would need to bear the cost. Right now, the data can be identified as ABC, which is each spreadsheet line number which appears on the far left side of the spreadsheet. March 11th, Colborn email production. On which basis you are asserting that all emails on March 11th from production and Mr. Colborn's emails to attorney eyes only. We ask you to revisit your blanket designation of the plaintiff's emails on attorney eyes only. Agreed to do so, and the parties agreed that you would provide an Excel spreadsheet with the confidentiality designation of these documents, which our e-discovery team and apply to the documents. As we explained, we are only concerned with the private information, such as addresses, phone numbers, and other personal information in emails. Again, we can identify which emails those are by the end of this week. Damages of witnesses. When will you supplement the January 28th, 2021 and February 16th, 2021 responses to the producer defendants Interrogatory number 10, which called you to provide an individual's full name, present, is not known, last known address, telephone number, email address, occupation, present, last known employer, as well as substance of each person's knowledge. In addition, requiring contact information and substantive knowledge of the individual identified on February 16th. Defendants also require complete identifying information and substance knowledge of all individuals described in vague detail in the January 20th response. With respect to outstanding information regarding the witness plaintiff identified a response to the producer defendant's interrogatory number 10, George indicated that he will ask plaintiff to provide telephone numbers, other formats of contact such as email addresses, in advance of counsel meeting. The plaintiff was scheduled for Monday. George indicated that we can expect a short description of the substance of each person's knowledge relative to plaintiff's damages claims for a counsel meeting with plaintiff on Monday. After further consultation with Mr. Colborn, we may be withdrawing some of those witnesses. We will provide information that you requested of those witnesses, whom Mr. Colborn intends to preserve as damages witnesses as soon as possible. We do not see a reason to respond at the time additional comments to your additional questions below, but this should not be taken as agreement with agreement that you've included your questions or comments. Do you anticipate producing documents in response to the Netflix second RFPs on Wednesday, April 6th? If not, what is your plan for production and response of records? We received your latest production, so thank you. Deborah indicates that at this time, plaintiff does not anticipate any further productions in response to Netflix second RFPs. When will your parties receive deposition notices for depositions planned for the last week of April, including Adam Del Dio, Loretta Riccardi, Maura Demos, and Lisa Nisamura? Which, with respect to the notices and depositions of the Netflix opponents listed above, Deborah emailed shortly after the meeting. We informed AM. Yeah, I read this already. This is like the same thing. We respect to Mr. Real Books regarding providing the copies of the copyright pages, books. I should have pre-read this before I went. I wouldn't have to reread all this stuff all over again. But I like to read these documents live when I go through them. So I'm just as surprised as y'all. The producer time produced copies extended these books are already available through Mr. Griesbach. Further, emotionally and related to Mr. Griesbach, we asked whether plaintiff would stipulate to the briefing schedule to schedule closer to the time of the trial in case it was yet to be scheduled. We further informed we will move to such a briefing schedule as the court has no reason yet to resolve the issue and the parties have other pressing discovery matters to resolve. You indicated that you would confer as a team as to promptly inform us of whether you will agree to stipulate briefing schedule or whether you would oppose our motion. April indicated that Mr. Colborn brought the motion in the hopes of somehow heading off disclosure of a large number of documents by Mr. Griesbach that would be time consuming to review during an already busy period of discovery. We said we did not know how many responsive documents Mr. Griesbach had, and that our meet and confer with his counsel was extremely unproductive, and his counsel did not agree to voluntarily disclose any documents. Upon further reflection, I would now note that whether the outcome of the motion in lien, such motions go admissibly, not discoverability. So regardless whether the motion in lien is decided, our position is that we are entitled to Mr. Griesbach's documents for the reasons set forth in the motion to compel. Thus, briefing the motion in lien over the next few weeks, rather than closer to trial, will in no way alleviate April's concerns about the need to review additional documents and will in fact just add to everyone's already full plates. Further, it will be difficult for us to respond completely to the motion in lien until we are able to see the documents that were requested by Mr. Griesbach. Finally, I wanted to make clear that Netflix's position regarding a few items in April's attached email. April wrote, we are also reminded that you consented to the extension of many of our deadlines in the case for the purpose of allowing time for discussion and resolution of alleged issues as extended possible. Netflix has not sought any extensions from the court in the case. Plaintiff and the producer defendants have sought extensions, but Netflix did not oppose. One time, Netflix indicated they needed a bit more time to get documents to you. Last October, you moved for sanctions, and the motion you later withdrew. April wrote, finally, with respect to Netflix designation of the email and messages involving MAM's production as confidential, we reiterate the concern that you have failed to supply any rationale of these designations in response to our prior inquiries. The problem that this creates is that, according to local rule, protective order is not sufficient basis for filing documents under seal. Separate requests must be made and identify the basis for designations. When we file our response to our eventual summary judgment motions, we will not have any basis for representing the court that should be filed under seal because we have not articulated one. In absence of the plausibility rationale for sealing these documents, we will need to seek direction from court will advance the summary judgment briefing regarding the proper treatment of these documents so that we are not caught in a bind during summary judgment briefing. I do not believe we have failed to respond to any inquiry about this, and if you can point to a specific inquiry, we'll try to find a response to the inquiry for you. At present, unless someone moves the court intervention of the designations, it seems we will all be in the same boat come to the summary judgment, since you too have designated everything confidential. In fact, unlike Netflix, and as discussed above and during our phone calls, you have designated a significant percentage of production of AOA, and we are open to the suggestion you want to make our deal with. We are 100% agree that the over-designation unnecessarily complicates this case. That said, we do not believe we are over-designated. April wrote, please also note that we are not completed an exhaustive list of deficiencies with the defendant's productions. We are reserved the right to request additional meet and confer conferences and may be necessary to appropriate as we continue our review analysis of Netflix and Chrome's productions. We are not sure which of the defendants you are talking about here and are concerned that you continue to affiliate Netflix with producer defendants. In asserting you have granted us many extensions, that said, we are always willing to meet and confer, though we are surprised to learn that the late date that you believe our discovery response are in way deficient. Although you have certainly had questions about the production related to raw footage of Google Docs, we have answered those questions and have never identified any actual deficiencies, despite our serving written responses 9 months ago and finishing our document production 5 months ago, October 28th, except for a small set of documents we're expected to produce in the very near future in response to your recently served 7th set. April George Mike. In addition to these matters already raised in Lederman's email, comments are run below. There are many additional follow-up items the parties meet and confer conference this week. You say that you would inquire Mr. Colborn on Monday regarding the arguments between him and entities, people behind the convicting documentary project. We believe that we are entitled to such agreements, and you stated that you would inquire as the existence of such agreements would advise us regarding that, you also regarding your position whether you will provide us such documents. In the absence of such agreement, we will be moving to compel with respect to such materials. As George indicated, we do not believe there is an agreement, rather authorization. We will be producing it based on your request, although I am not certain that it is responsive to any of your specific formal requests. Your represented the plaintiffs was not instructed to time limit searches for documents and communications after December 2015. In response to my point out of the paucity of such materials in plaintiff's production to date, you stated the plaintiff's position is that he is now, as of April 7, 2022, produced everything responsible in his possession, but that you would confirm that the case of Mr. Colborn, when you speak on Monday, rarely you stated the plaintiff's position that he does not possess any responsive emails or text messages that predate December 2015. I believe you said that you would confirm this, Mr. Colborn, when you speak on Monday, but if I'm correct in recollection, I would ask you to say, I would ask now that you do so regardless. Plaintiff's position is that he does not possess any responsive email messages or text messages that predate December 2015. You say the plaintiff's position is that he does not possess any documents contemporaneous to the events he placed at issue of the case, the Second Amendment complaint, stating in 1994, 1995, and including 2003 to 2007, other than the modest amount of documents he has already produced. Again, you stated that you would confirm with Mr. Colborn when you speak on Monday. Plaintiff had produced what he believed to be all responsive documents, but he is double-checking this, and responsive non-privileged documents identified will be produced. Mr. Colborn likely will also produce any near future some additional documents as to which privilege claims for these documents may be abandoned, but they do not relate to the time frames that you have identified. Mr. Colborn simply he had no reason, nor did he retain many documents relating to the events where underlying subject of MAM. You say that you would check with Mr. Colborn on Monday regarding his hshs.com email account, whether there is a response of documents there. As I pointed out, that Mr. Colborn sometimes such emails from Manitowoc County Sheriff's Department account would work there. Mr. Colborn indicates that he is represented by a firewall from sending messages from his hshs.com email account Those responses messages Mr. Colborn forwarded from his other account to the hhs.com account has been produced. I call bullshit. You stated that the plaintiff's position is that you search for all types of formats, documents. Just limited to the emails and text messages. He produced all responsive documents in his possession. Although I believe you said that you would confront Mr. Colborn when you speak on the money and collection, and you do so regardless. Correct. The search was not limited to email messages and text messages. You stated the plaintiff's position that you produced all documents providing the factual basis for damages, claims, and calculations. We note that the lack of information provided regarding Mr. Colborn's pension and hospital wages. Does the April 6th production you made cover that, or should we expect that such financial documents are forthcoming? Please note that the hospital or pension income should be a reflection in Mr. Colborn's tax returns, which you have now produced. Please advise whether it satisfies your request. Plaintiff has not produced documents regarding mitigation and damages, financial opportunities. He has offered a relation to the prominence for making a murder, such as speaking opportunities and garments for the producers convicting. Please produce such documents for confirming and writing that Mr. Colborn's position is no such documents exist. Correct our knowledge that such documents exist. Other than the extent the text messages already produced may have referenced speaking engagements that Colborn did not attend. While I do not believe we arranged this at the meet and confer calls, I note that plaintiff has produced in discovery negative messages he received from public, but has not provided any more positive messages, including fan mail that has reference. Colborn has fan mail? I doubt that. He received after reference receiving his writings. Please produce any such positive messages and fan mail related to the making a murder. It was my impression that the term fan mail may have been used sarcastically to refer to negative messages. However, Mr. Colborn does not have any positive fan mail related to the making a murder in his possession, other than anything that was already produced, unless there were maybe some documents and materials provided to Geraldine Dietz. Mr. Colborn may abandon privilege claims as to some materials that he provided to Ms. Dietz, but not as to other confidential communications with Ms. Dietz while she was assisting him in attempting to pursue the claims that ultimately were filed in this case. Plaintiff will supplement certain discovery responses, including responses to the RFA 1 and interrogatories 1257. Producer defendants, please let me know if I'm mistaken as to specific items for which Mr. Colborn has agreed to supplement. And our goals, supplement indicated responses by the end of this week, bearing additional interruptions, particularly those related to this case. We discussed working together to resolve issues with accessing the media attachments to the text message that Mr. Colborn produced. This is not clear to me whether he has not been completely resolved or whether we still have finished addressing the issue. If you need to have your tech staff reach out to Deborah Bursick to further address these issues, please feel free to have them contact her. I'm not going to read the phone number. You stated the plaintiff's position does not possess certain documents and communications. March 23rd, 22 letter and missing from production despite plaintiff's direct references them in the documents which would confirm Mr. Colborn on Monday. The specific documents, communications, physical files, including fan mail, dropped off by Joe Dietz Law Office in February 2016, as referenced in January 2016 email with Geraldine Dietz. February 2017 emails of numerous individuals, including DOJ, the DA, circulating an article in a jailhouse confession letter, referenced in text messages with Brandy Rima and several other individuals. October 2017 emails with Mark Wiegert. And regarding Kevin Ramlow in a November 2005 call to dispatch. Let me read that again. October 2017 emails with Mark Wiegert regarding Kevin Ramlow and the November 2005 call to dispatch. I don't think I've ever heard this call from Kevin Ramlow to dispatch. And if he's talking to Mark Wiegert, that means it's got to be in Calumet County's dispatch. I wish they would actually specify the day, because there's 19,038 files, but there's only 3 channels that are, well, 2 channels if it's dispatch calls of importance. I've already been over that shit several times. I do not want to listen to that again, but if I have to, I will. Communication with Joe Creel, others reflecting opportunities to make some serious cash on speaking circuit, and agreements with convicting producers that prevented him from taking such opportunities, referenced in October 2007 text messages with Joe Creel. With respect to fan mail, please see discussion of that issue above with respect to the other going to answer. Please to clarify one point seen the source of confusion. On April 5th, 2022 email, April explained plaintiff discovery response referring to MTSO's production by saying, "We attempted to inform you that we would not be including in Mr. Colborn's response copies of the very same documents that are obtained from the Manitowoc County production." Defendants understood this to mean that Colborn has some copies of emails included in the MTSO production that he did not produce himself. But then, during the April 7th, 2022, I believe Deborah represented there were no duplications and the plaintiff had produced all emails in his possession. To the extent that Mr. Colborn independently possesses the very same documents that were obtained from Manitowoc County production, please produce them. We're glad to address duplication of our end and most concerned complete search of the production. There are such duplicate. The yellow highlighted statement above is correct. This is not correct. Colborn has some copies. Okay. One item I would note, in appearing from the MTS production, there was an MTS email exchange with the Phantom Fixer email account that plaintiff did not produce in his email production. Please produce those and any other responsive emails that plaintiff did not previously produce to us. In responsive email messages existed in exchanges with the Phantom Fixer email account, there did not appear to exist there now, or to our knowledge. We have reviewed the specific examples that you identified to confirm this. If there are additional specific examples you would like to bring to our attention, please identify them. As I mentioned on the call, producer defendants have produced another production forthcoming in the coming days. Given the breadth of the request served by plaintiff and producer defendants March, has taken time to compel the volume Exhibit 6 email from Deborah Bursick to George Burnett. Just download attachments. Exhibit 7, Lita Walker to Solomon Esmito, Isabella Parsons, Emmy, Matthew Kelly. I'm following up April's response to summary of the meet and confer April 6th and 7th attached. I think we're resolved most issues, but just want to confirm that we stand to tie up a few loose ends. I also included a few new issues which were not discussed in our meet or confer, but have come to our attention in recent days. We continue to review Mr. Colborn's response to Netflix's second set of requests for production, including the documents he produced, and expect to raise additional issues in the near future. Designations in Manitowoc County documents. You have withdrawn all AOA privilege designations from the documents. We do not have any issue with the confidential designation in 4/15/2022. We will mark the Manitowoc County documents first set to produce on 2/9/22 with the confidential designations you sent on 4/15 and use that set going forward. Detailed Manitowoc County documents were in the process of confirming whether we can identify the duplicate documents emitted from the production in 2/9, and we'll circle back to the unable to do so. Destination and email served to 3/11/2020 AOE. You agreed to review the destinations but did not believe we received any adjustments. Please let us know when those are coming. Text messages previously withheld pursuant to claiming a third-party journalist privilege, spousal privilege. You served on 4/18. It appears you were withholding any text messages at the point, except those who claimed client privilege. You can please confirm. You also said that you would withdraw the claim that making murder caused Mr. Colborn's divorce for purpose of these proceedings. We're not sure So Colborn is going to take back the claim that the documentary caused him to have a divorce, because if he goes with that claim, that means they have the right to talk to his wife, and I'm sure he doesn't want her saying anything. Yeah, pineapple. Can you confirm the texts which you confirmed the claim attorney privilege were in group text and non-lawyers of Brendan Schuler? And can you confirm that the substance of the text ways are otherwise shared via forwarding, copying, and pasting? Otherwise, with non-lawyers such as Brendan Schuler or Barb Colborn are reviewed in case Mr. Colborn would often receive a text or email from his counsel and then immediately share his content with Ms. Schuler or Ms. Colborn, and that is a waiver of the privilege even if neither woman was occupied in an initial text or email. When you initially produced text messages to us purported to designate attorney eyes only, we understand you withdrew the destination of the text message. None of the text messages were ever received. As they branded the destination, we are overlooking something. Please let us know. You agreed to provide additional information on the damages with Mr. Colborn, identified and possibly withdraw some when we expect the supplemental information, new issues. In the new documents you produced on 4/14, we are seeing many redacted documents despite the inclusion of non-attorneys such as Brendan Schuler portion of the emails chain. See Colborn 044. We also see an indication that Ms. Schuler was included on many of the legal strategy discussions. See Colborn. We believe redaction of the documents, which includes Ms. Schuler on the chain, which were shared with Ms. Schuler, and which involved substantive discussions of Ms. Schuler was privy in writing otherwise inappropriate, and inclusion of Ms. Schuler was these legal strategy discussions indicates that she has been a significant and broad waiver in attorney-client privilege in this case. Please let us know if you will agree with withdrawal of such redactions. Likewise, in the new documents produced in 414, we are seeing many redacted documents despite inclusion of John Mayer and the productions in the email chain. See attached example. We are confused by Mr. Mayer's role in the case. We understood that he represented Mr. Griesbach, not Mr. Colborn. This seems including Mr. Mayer on emails between Mr. Griesbach and Mr. Colborn would be subject matter waiver with regard to the entire conversation. Please let us know if you agree to withdraw these redactions. Our interrogator number 4 asks the email and social media accounts of Mr. Colborn are maintained or created from 2015 to present, and the answer says he only has non-created any such accounts during the relevant time period. Please supplement in the answer with a list of accounts maintained during the time period, if any. Attaching documents contain Kevin and Lita's messages and providing responses as a bold-faced type. It seemed that he would be unwilling to try to send these responses to the emails message point, and was concerned that we might lose font coloring and highlighted the screens of the comments. Maybe you're speaking to the point. I missed an issue. Please let me know. April. Exhibit 8. We're almost getting to the end of this. April Baker, highlighting below response to your questions. Please let me know if you're in for information and clarification. Designations in Manitowoc County documents. You have withdrawn all attorney eyes only privileged designations from the documents. We have any issue with the confidential designation you sent on 4/15/22. We will mark the Manitowoc County documents. The first set you produce as 2/9/22 with the confidential designation you sent on 4/15. Use that to set forwarding. Do you do Manitowoc County documents? We are in the process of confirming whether we can identify the duplicate documents emitted from the production of 2/9, and we'll circle back if we are unable to do so. Designation: all emails are served at 3/11/22 as attorney eyes only. You agreed to review the destination in which you believe to receive the adjustments. Please let us know when those are coming. We are designating them as confidential rather than attorney's eye only. Please can advise whether you need a spreadsheet to this effect. The text messages previously withheld pursuant to claim third-party general privilege, spousal privilege. You served this on 4/18/22, and it appears you are not withholding any text messages at the point, except those which you claim attorney-client privilege. You can also please confirm this is correct. You also said you withdraw the claim that making murder caused Mr. Colborn's divorce for purposes of these proceedings. Was not sure whether on said limitation, given you can explain what you mean. Withdrawing the contention of this case, Mr. Colborn is not limiting his ability to express his personal beliefs about the impact of MAM on his marriage and other settings apart from this case. You can confirm that the text from which you continue to claim attorney-client privileges are not group text, including non-lawyers such as Brenda Schuler, and you can confirm the substance. With the text message otherwise shared via forwarding, copy, and pasting otherwise, non-lawyers such as Brenda Schuler, Barb Colborn, and other reviews indicate that Mr. Colborn would often receive text and email from his counsel immediately after sharing contents with Ms. Schuler or Ms. Colborn, and his lawyer waiver of privilege, even if neither woman copied of the initial text and email. We would produce all materials forwarded to those who were not attorney counsel. When you initially produce text messages forwarded to the destination and them all attorney eyes only, we understand that we are withdrawing the destination and all text messages. None of the text messages have received as stated branding with any destination. If we are overlooking something, please let us know. Text messages are being designated as confidential with telephone number column removed, so they are no longer needed attorney eyes only production. You have agreed to provide additional information and damages with Mr. Colborn and the possibility of withdrawal of them. When can we expect supplemental information? We expect to provide supplemental information on Monday. New issues in the document produced on 4/14. We are seeking many redacted documents, despite the inclusion of non-attorneys such as Brenda Schuler on a portion of the email chain. See Colborn's 04635. We're all seeing indication Ms. Schuler was engaged in many legal strategy discussions. See Colborn 4593-2807. We believe the redaction of documents, which include Ms. Schuler on the chain, which was shared to Ms. Schuler, which involved subsequent discussions on which Schuler privy, writing or otherwise inappropriate, and inclusion of Ms. Schuler to these legal strategy discussions indicates that there has been a significant and broad waiver of attorney-client privilege in the case. Please let us know if you've agreed to withdraw such redactions. The redaction debates NOS. The email messages which Brenda Schuler was included, which she was on an earlier part of the email thread, was dropped from the chain. I believe that's some of the responsive documents that are produced to you. Ms. Schuler indicates that Attorney Griesbach advised her she could not be part of the legal team. We do not believe she can be properly or accurately characterized as involved in setting legal strategy. April, Exhibit 9. Email from Salamano Nascimento to Deborah Bursek, April Baker. Thank you for your email. April 22nd email that a reference address only email is produced by March 11th. Similarly, the email providing March 11th production of Mr. Colborn's email stated that providing designation of email messages in production, we have received any purported confidentiality designation for substance production to plaintiff for possession of the documents produced in March 11 productions treated as confidential, and these please specify the documents in production you believe are confidential. Finally, we have previously discussed the party's ESI protocol. It makes clear that the document that party intends to designate as confidential should be stamped as such when produced, and plaintiff's supplemental production continue to grow. It becomes increasingly difficult for us to track which productions plaintiff believes should be treated as confidential. Should the plaintiff produce any additional documents except for the plaintiff will prior to production stamp the documents in accordance to the protocol. It's important both so that we avoid confusion regarding the status of any asserted confidentiality privileged designations, and that we may more fully expectantly consider and necessarily challenge asserted designations. Thank you. Per April D. the Friday. We will be filing our applied Netflix motion to compel by the close of business today. We are planning to include as many exhibits as attached documents produced on April 14th. These documents were produced whether any confidentiality designations branded in the documents asserted in the cover email as a courtesy right to conform that we therefore in turn file a reply exhibits publicly. If you disagree with the course, please notify us promptly. This will then require that we file a motion to seal, which we will make clear to the court we object to the sealing of documents that believe the motion should be denied and all records made publicly available. Well, that was fun. Hour and a half out later. A lot of that is just a bunch of repeating mumbo jumbo, in my opinion. But for those of you that are still watching at this point, basically we're waiting on Judge Ludwig to sign off on Netflix request for everything that they requested from Griesbach and Colborn. But Ramlo phone call to dispatch. I'm not aware of Kevin Ramlo calling to dispatch. But based on what Kevin Ramlo has stated, he witnessed the vehicle there on the 3rd. He talked to the officer at the gas station on the 4th. So I'm assuming he called after the 4th. Now, if he called Manitowoc, I don't know. But I'll see y'all next time. Later.